Just a second. What do you want to say? All rise. The International Criminal Court is now in session, hosting the ICC Moot Court Competition 2025 English edition.
Please be seated. I also welcome the courtroom staff, the security officers, and I also greet those in the public gallery, which is quite full, I think. I actually thought we were in courtroom 1, where there is even more space, and I first went downstairs, so I had to find my way to courtroom 3, which has a huge advantage. It's not as big as courtroom 1, but it has the advantage we have, at least from the deliberation room, a wonderful view until the sea. I also greet, of course, the participants in the ICC Moot Court competition attending this hearing, and those outside the court joining us via the internet in this Moot Court competition. Court officer, please call the case.
Thank you, Mr. President. We are sitting in the appeal session regarding the pretrial chamber's denial of confirmation of charges in the case of the prosecutor versus Arrix Fragar in the situation of the Republic of Norteros, ICC Moot Court Competition 2025 English edition.
Thank you. On behalf of the Chamber, I would now ask the parties and participants in this hearing to introduce themselves, but before we do that, I would like to remind everyone of the cardinal sin committed in courtrooms, that is speaking too quick and not waiting a couple of seconds after a question has been asked till you start with your response. So we start with the attendance, and we start with the prosecution, please.
Mr. President, Your Honors, my name is Timo Dahlmann, and I appear on behalf of the Office of the Prosecutor in these proceedings. I am accompanied today by my co-counsel, Mr. Jonathan Rasbach.
Thank you very much. I turn now to the representatives of the victims who participate according to Article 68, Paragraph 3 of the Rome Statute.
Mr. President, Your Honors, good day. I'm Nikita Cordova, and together with my co-counsel, Mr. Arvin Ahesta, we are appearing before you as the common legal representative of the victims.
Thank you very much.
You.
And of course, I turn now to the defendants, and please let me know who you are and who your colleague is.
Good morning, Mr. President, Your Honors. My name is Ms. Leah Yo, and with me is my off-counsel, Mr. Wong Ziyang. Together, we act for the defendant, Mr. Arrix Fragar, before today's appeal. Thank you.
Thank you very much. The team of the registry is represented today by the court officers. First of all, Marisela Garcia, actually who assisted me and several chambers with my colleagues over many years. I'm happy that she is here today. I didn't know that, actually. Ahmed Al-Yuburi, Martin Prochatska, and Victoria Araujo Silva from the Grotius Center for International Legal Studies. And they are very important because they are the timekeepers, so if I understand correctly. And we all know when time is up, and no further argument can be made. Finally, you have also the right, so to speak, to know the bench. To my right is Andrew Marylees. To my left, Yorick Kim. And my name is Bertram Schmidt, and I'm presiding today. The Chamber will now proceed consecutively with the three issues shaping the subject matter of today's hearing. Being mindful of the public nature of this hearing, I would ask the court officer to please read the agenda established by the Appeals Chamber.
Thank you, Mr. President. Pursuant to Pretrial Chamber 15's decision to grant the prosecution's request for leave to appeal the denial of confirmation of charges of 15 September 2024, the Appeals Chamber seeks submissions of all parties and participants on the following three issues. A. Whether the Pretrial Chamber erred in finding that the ICC lacked of jurisdiction over Alex Fragar under Article 12(2)(b) of the statute because he lacked a genuine link to Petons, a state party to the Rome Statute. B. Whether the Pretrial Chamber erred in finding that the allegations and evidence are insufficient to establish substantial grounds to believe that Alex Fragar aided and abetted the commission of the inhumane act of gender apartheid under Article 7(1)(k) and Article 25(3)(c) of the statute. And C. Whether the Pretrial Chamber erred in finding that Alex Fragar cannot be tried for committing an offense against the administration of justice under Article 71(c) of the statute when the web platform that he created and controlled published a confidential document hacked from the ICC that included the names of anticipated witnesses in this case.
Thank you very much. So these are the three issues that we are dealing with today. And of course, you are confined to these three issues, and I will give first the floor to the prosecution for its submissions.
Mr. President, Your Honors, since November 2021, women in Northros have been confined by the Belen regime, not by walls but by policy. But that regime does not sustain itself. Mr. Alex Fragar, the defendant, created an autonomous rifle system, entrapping women within this architecture of control. And when the pursuit of justice drew near, Mr. Fragar struck at its core by contributing to the unauthorized disclosure of confidential information, jeopardizing the safety of the witnesses and the integrity of these proceedings. His actions fall squarely within this court's jurisdiction and meet the legal threshold for confirmation of charges. Thus, the prosecution kindly requests the Chamber to grant the appeal as the pretrial chamber erred in law, concerning firstly that the pretrial chamber erred in suggesting that the court lacked jurisdiction under Article 12(2)(b) over the defendant. Secondly, the pretrial chamber erred in finding that the allegations and evidence are insufficient to conclude that substantial grounds to believe are established that Mr. Fragar aided and abetted the commission of another inhumane act under Article 7(1)(k) and 25(3)(c) of the statute. And finally, the PTC erred in finding that the defendant cannot be tried for committing an offense against the administration of justice under Article 71(c) of the statute. Your Honors, coming to our first submission, the pretrial chamber erred in law in denying jurisdiction over Mr. Fragar under Article 12(2)(b). As pursuant to Article 12(2)(b), the court may exercise jurisdiction if the accused is a national of a state party to the statute. In our case, the defendant is a national of Pentos, a state party by birth. However, we note that he is also a national of Davos, a non-state party by descent, making him a dual national. The pretrial chamber erroneously subjected the jurisdiction over a righteously conferred nationality of a dual national under Article 12(2)(b) to unprecedented additional requirements under the label sufficient link. First of all, the statute itself in its wording or the court in its jurisprudence do not foresee such unwritten additional requirements for exercising jurisdiction under Article 12(2)(b). Rather, the court in its past jurisdictional decisions For example, in the Myanmar-Bangladesh authorization decision in paragraph 59, has decided that if the plain language of a provision allows for jurisdiction, then there is no reason to conduct an interpretation limiting the exercise of jurisdiction. In the same light, it was specified by the pre-trial chambers of the situations in both the Central African Republic and Palestine that in an interpretation in light of a treaty's object and purpose, a provision must be given their fullest weight and effect, which would be hindered not only regarding the competence of the court to exercise jurisdiction under Article 12(2)b, but inevitably also concerning the statute's aim to end impunity and protect human rights, as emphasized by Article 1 of the statute and the preamble. As no indicators of additional requirements are present in the court's law, to interpret Article 12(2)b in requiring a sufficient link would therefore be contrary to the statute's wording and the respective practice in jurisdiction. Also, Your Honours, it is important to note that the court derives its jurisdiction, as stated in paragraph 60 of the Bangladesh-Myanmar authorization decision, from the delegated jurisdiction of state parties, and as a consequence, it may, as stated in paragraph 70 on the decision on the prosecutor's ruling on jurisdiction, thus exercise jurisdiction in the same circumstances as they do. In this regard, we note that the state practice concerning dual nationals is indeed sparse. However, this does not preclude the exercise of jurisdiction by a state over its national, as shown by the Lotus Principle, which stipulates that due to the often unclear status of international law, jurisdiction is only limited by prohibitive rules. This principle, while derived from the 1970 Permanent Court of International Justice's Lotus case, has been reaffirmed by the International Court of Justice, for example, in its nuclear weapons advisory opinion of 1996. This shows, in other words, that a limitation to a state's jurisdiction cannot be presumed. And a limitation cannot be presumed, in our case, as additional requirements to the exercise of jurisdiction under Article 12(2)b are not established rules of international law. In consequence, as the court derives its jurisdiction from the state parties, it is not restricted in the exercise of jurisdiction. Therefore, overall, unlike the PTC found, Article 12(2)b is not subject to additional requirements under the label sufficient link. Therefore, the court has jurisdiction over the defendant as he is a national of Pentos, a state party.
No. I have a little bit of difficulty to activate the microphone. Well, I have a question on that. You mentioned at the end of your submissions to that point, you mentioned the ICJ. Can you tell us where this idea of sufficient link comes from?
Your Honor, the idea of sufficient link is per se unknown to international law. However, there are other principles that would describe the same circumstances as the sufficient link, which would be, for example, the genuine link, as emphasized by the defense's submission. However, we note that the genuine link principle, which was developed in the Nottebohm case, in the 1955 Nottebohm ICJ case, that this genuine link requirement is not even recognized in its restricted realm of diplomatic protection, that is. For example, 15 years after the Nottebohm case, in the diplomatic protection case of the Barcelona traction case, more precisely in paragraph 70, where the genuine connection required in Nottebohm 15 years earlier was deemed as a test relative to that specific case, and, I quote, there can be no analogy with the issues raised or the decision given in that case, end of quote. Your Honor, I am telling you this because not even in the realm of diplomatic protection is the principle of a genuine link bound to nationality. And in any case, we cannot derive a principle that would derive from the genuine link principle from Nottebohm to the exercise of jurisdiction of individual criminal jurisdiction under Article 12(2)b of the statute.
Thank you. Questions on that way?
Yeah, I have one question, Counsel. So I agree with you that Article 12(2)b merely mentions the state of which the person accused of the crime is a national, and there's no further preconditions there. However, why should the court not be guided by the procedures as set out, for example, in Article 36(7) of the statute, which obviously relates to the nationality of judges, and I'll read it for the record. So no two judges may be nationals of the same state. A person who, for the purpose of membership of the court, could be regarded as a national of more than one state shall be deemed to be the national of the state in which that person ordinarily exercises civil and political rights. So why should the court not be guided by this principle, obviously, which the statute makes provision for?
Your Honor, the prosecution is aware of Article 36.7, which acts upon the judge's appointment. And the prosecution would like to note that the purpose of Article 36.7 serves a different purpose, and namely not the exercise of jurisdiction, but rather the fair geographical representation of the judges of the ICC. And we should also note that the drafting of Article 36.7 and Article 12.2b, namely the jurisdictional provisions, have been conducted by different working groups that did not know about each other's problems.
Then please proceed with the second issue.
Proceeding to the second issue, the pre-trial chamber erred in holding that there are not substantial grounds to believe that Mr. Raga aided and abetted the commission of another inhumane act. As we have an aiding and abetting constellation, it is important to differentiate between the principal's crime and the accessories acts. Firstly, coming to the principal's crime, the Balearian Acts constitute a crime against humanity since they qualify as another inhumane act under Article 7.1k of the statute. I will emphasize from the beginning that the use of the term gender apartheid in the following is not meant to establish gender apartheid as a standalone crime of the statute, but is rather used as a description of the situation in Northwest, which fulfills the requirements of other inhumane acts under Article 7.1k of the statute. And such other inhumane acts are classified as acts causing great suffering of similar character to any other act referred to in Article 7.1 of the statute. We note that similarity in character is defined as nature and gravity of an act pursuant to Article 7.1k footnote 30 of the element of crimes. And it was stated in the Ongwen judgment in paragraph 2746 that similarity in nature and gravity are assessed by the act's context and its impact upon the victims. And in this light, we note that gender apartheid is first of all similar to racial apartheid under Article 7.1j of the statute. Racial apartheid specifically criminalizes the institutionalized character of discrimination and oppression based on race. Northros issued several decrees barring females from their rights and liberties and brutally enforced them over a long period of time, as shown by Appendix B5, thereby creating and maintaining institutionalized discrimination based on gender. Also, gender apartheid is similar to gender persecution under Article 7.1h of the statute. As assessed in paragraph 991 of the Interganda judgment, nature and gravity of gender persecution are characterized by discrimination based on gender and the severe deprivation of fundamental rights as enshrined in international human rights law. And the court itself in Al-Hassan has already clarified that work, education, and freedom of movement constitute such fundamental rights, of which, as shown by Appendix B5, women in Northwest were severely deprived on a discriminatory basis. The Balearian Acts are thus of similar character to gender persecution. Your Honors, we acknowledge that gender persecution may be layered inside gender apartheid. However, similarity does not mean that a conviction under Article 7.1k of the statute can be entered only when the conduct in question falls completely outside any act under Article 7.1a to j. Rather, as described in Ongwen, a conviction can be entered under Article 7.1k when the full scope of the culpable conduct is not reflected by its qualification under an enumerated crime alone. In this regard, the full scope of the culpable conduct of gender apartheid is not reflected by gender persecution. To further illustrate this, the inclusion of the crime of racial apartheid, in addition to racial persecution, reflects the distinctiveness of a discriminatory system when it is institutionalized. In the same manner, the full scope of the culpable conduct of institutionalized discrimination in Northwest is not adequately reflected by gender persecution. So, in conclusion, the Balearian Acts are of similar character to other acts referred to in Article 7.1, and as they are also being knowingly committed as part of a widespread and systematic attack against the population of Northwest, the Balearian Acts also fulfill the contextual elements of Article 7.1. And overall, unlike the PTC stated, the Balearian regime's acts constitute the crime against humanity of gender apartheid under Article 7.1k as another inhumane act.
Yeah, Council, I have a question for you on this. So, the crime of apartheid, as I understand it, has an inherent racial element to it. Would you agree with me on that front?
Of course, Your Honor, we agree with you.
So, where is the racial element here in this fact pattern? Because ultimately, as far as I can see, there isn't one. And as you've already alluded to in your submissions, gender persecution would appear to be a more appropriate classification of the crimes in question here, the alleged crimes in question, rather. So how do you get over this issue of the kind of racial aspect which is not appearing in the fact pattern as I see it?
Your Honor, we note the racial aspect of racial apartheid under Article 7.1j of the statute, and therefore the prosecution would 100% agree that it would be legally untenable to subsume gender apartheid under the crime of apartheid under this Rome statute. However, we are subsuming the crime of gender apartheid under other inhumane acts of Article 7.1k. And the fact that you described how the system in Northwest is similar to the crime of apartheid, only in that it differs from racial apartheid in the terms of race, that the innate characteristics that are targeted is gender in this case. This shows that it is indeed of similar character to crimes that are known by the statute and are therefore to be subsumed under Article 7.1k of the statute.
Just to come back to you on that, but the crime of apartheid, the word apartheid, as I understand it, has a racial element. So you're just decoupling. You can't say racial apartheid because it's apartheid. It's already subsumed. The racial element is already subsumed in the word apartheid. So I don't quite follow your argument here.
Your Honor, we agree that apartheid per se has already innate the element of racial in itself, in its description, and to excuse my wording, it would be wrong to conclude that racial apartheid is a thing that is different from apartheid itself. However, this is why we are not subsuming under the crime of apartheid, as we fully agree that such a racial element is not met from the acts of the Balearian regime in Northwest, which is why we subsume it under Article 7.1k of the statute.
Please proceed with the third issue.
Thank you. Your Honors, concerning the third issue, the pre-trial chamber erred in law and fact in holding that Raga cannot be tried for committing an offense against the administration of justice under Article 71c by publishing the unredacted Human Rights International report that included the identifying information of Morgul and Shrika. Article 71c has been described in paragraph 737 of the Bemba et alia appeal as a conduct crime not requiring a proof of effect on the witness. It was also described in the appeal's judgment as an open-ended provision encompassing many modes of commission capable and likely to deter a witness from giving testimony. In its footnote 81 of the judgment, the court referred to the practice of international tribunals using catch-all clauses, broadly capturing the conduct of contempt. This is supported by Article 68.1's directive and how it is the court's duty to do everything necessary to prevent unjustified risk to the witnesses in protecting witnesses' safety, psychological and physical well-being, as well as privacy and dignity. In this regard, the disclosure of confidential information generally poses a risk to witness safety, exposing them to retaliatory actions. As Morgul and Shrika occupied prominent roles in Ragasov Corp, as emphasized by Appendix B8 and 16, they took a personal risk by providing incriminating information to the OTP. And both witnesses knew about this risk as shown by their request for anonymity in Appendix B2. And the published report only differs from the redacted version in that it included the potential witnesses' identifying information, depriving them of their anonymity. The names of Morgul and Shrika were kept redacted and thus kept anonymous as a measure of witness protection, until further measures pursuant to Article 54.3e and 68 of the statute, which were the condition of making their names public, could have been implemented. The publication of the report hence exposed the witnesses to serious risk and was therefore capable and likely to obstruct them from giving testimony. Also, Mr. Raga acted with the necessary intent. The general intent of Article 32 is applicable to the crimes of Article 70 by virtue of Rule 163 of the Rules of Procedure and Evidence. And concerning the intent, the International Criminal Tribunal for Yugoslavia, in its Margetic judgment in paragraph 73, has inferred intent and knowledge for contempt in the case of interference from the confidentiality markers on the published information. In this light, Raga had intent in relation to his conduct pursuant to Article 30 of the statute, since he had full control over the publication process at CyberLeaks, and nothing was posted without his permission, as shown by Appendix B17, and he only published those documents that he personally deemed to be in public interest and authentic. Also shown by the prosecution's login markers at the top of Appendix B, Raga knew that this report is confidential and that it was provided to Human Rights International under a confidentiality agreement pursuant to Article 54(3)(e) of the statute. Consequently, he knew of the witnesses' concerns and that it would expose them to retaliatory actions. Therefore, he was certain that publishing this information would lead to the obstruction of justice under Article 71c. And overall, Raga intentionally obstructed and interfered with the attendance and testimony of witnesses. Thus, unlike the PTC suggested, he can be tried for committing an offense against the administration of justice under Article 71c. Your Honors, coming to an end, it was established that the pre-trial chamber erred concerning all three issues, and instead the appeals chamber should rule that the court has jurisdiction over the defendant, that there are substantial grounds to believe that the defendant aided and abetted the commission of another inhumane act, and that the defendant can be tried for committing an offense against the administration of justice. Your Honors, the statute shall not shield those who commit international crimes from behind a keyboard or from a boardroom. Justice must not be selective. It must not only read the hands that strike, but also the perpetrators that enable and the minds that design. In this light, and also mindful of justice, the prosecution kindly requests the chamber to grant the appeal on all issues and confirm the charges against the defendant. This marks the end of the prosecutor's submission. Thank you for your time.
Thank you very much. Further questions? No, there are no further questions by the bench, so then we can immediately proceed to the legal representatives of the victims. You have the floor.
Mr. President, Your Honors, once again, good day. I'm Nikita Cordova, and together with my co-counsel, Mr. Arvina Hesta, we are appearing before you as the common legal representative of the victims. Your Honors, before I proceed to presenting my three prayers before the court, allow me to contextualize this situation for you. In paragraph 5 of Appendix B, the Balaran regime issued 4 decrees that systematically erased women from public life, by barring them education past the age of 8, by barring them employment in government positions, serving as doctors, lawyers, teachers, or nurses, by even limiting and restricting their freedom of movement. Your Honors, however, even in their escape, the women of Northeros saw no freedom, because Saldaros, with Vregar's help, installed the ABSS, a shoot-to-kill system that shot them and killed them as soon as they crossed the Rocky River. Your Honors, together, they created a geological and legal prison that made the price of defiance certain death. Against this factual backdrop, Your Honors, allow me to present my three prayers before the court. First, that the ICC has jurisdiction over Vregar under Article 12(2)(b) of the Rome Statute. Second, that gender apartheid qualifies as an other inhumane act under Article 7(1)(k), and that Vregar aided and abetted this crime under Article 25(3)(c). And third, that Vregar committed an offense against the administration of justice under Article 71(c). With this, Your Honors, I will now proceed to my first prayer, that the ICC has jurisdiction over Vregar. Your Honors, allow me to clarify that jurisdiction is only an issue in this case because paragraph 13 of Appendix B will show you that Vregar is a dual national of Pentos, a state party to the Rome Statute, and Davos, a non-state party to the Rome Statute. and the ICC only exercises jurisdiction over state party nationals. However, Vregar being a dual national should not diminish this court's jurisdiction over him. With this, Your Honors, I will now present to show you how we differ from the prosecution. Because while the prosecution established this ordinary meaning principle through cases in the OTP, I will present to you the case of Lubanga, specifically in paragraph 34, which proves that the ICC in the Rome Statute already has an exhaustive jurisdictional framework. Your Honors, this means that there is no need to import or apply any additional or extraneous tests on the provision of nationality in the Rome Statute because it is already sufficient and already encompasses situations like Vregar's. Your Honors, when we read Article 12.2b, it does not require the court to assess the strengths or genuineness of one's connection to a state party. Instead, it suffices that the individual is a legal, bona fide, and formally recognized national of that state party. Even the facts will tell you, Your Honors, that neither Pentos nor Davos contest his dual nationality. Even Davos only agreed to not cooperate with the ICC based on the fact that they are not a state party, and they do not even contest that Vregar is a Pentos national as well. To conclude this first prayer on jurisdiction, Your Honors, it is our position that to impose a standard on the provision of Article 12.2b, which requires the applying of any additional or extraneous tests, would be to erect hurdles, barriers that deny victims access to justice based on a standard that the drafters never even intended. If there are no further questions, Your Honors, thank you. I will now proceed to my second prayer, that the crime of gender apartheid qualifies as an other inhumane act under Article 7.1k, and that Vregar aided and abetted this crime under Article 25.3c. For my first point under the second prayer, Your Honors, that gender apartheid qualifies as an other inhumane act under Article 7.1k. Your Honors, paragraph 2747 of Ongwen shows that a crime is considered an other inhumane act when it is of a sufficient nature and similar in nature and gravity to other listed crimes, but however, they cannot be subsumed as such. In this case, it is our position that the crime of gender apartheid meets this requirement. The facts will show you, Your Honors, that the crime of gender apartheid was committed by both Northeros and Southeros. Contrary to the position of the Office of the Prosecution, the victims will submit to the court that the gender apartheid here was not just committed by Northeros, but by Southeros as well, because as can be gleaned from the facts that the definition of gender apartheid is more than just an institutionalized and systematic regime of oppression and domination by one gender group over another, but it is also present and important that there is an intent to maintain that regime. It is our position, Your Honors, that the institutionalization and systematic oppression and domination of the women of Northeros came initially through the 4 decrees that were issued by the Balaran regime that barred them from employment, restricted them from their freedom of movement, and even barred them from going to school past the age of 8. However, the women, even under living this system of oppression, Your Honors, still attempted to flee anyway. However, it was the Southeros deployment of the ABSS which ultimately made their escape impossible. Because, as can be gleaned from paragraph 9 of Appendix B, Southeros deployed the 60 automated rifles, Your Honors, along the border that was directly facing Northeros. This ensured that the women who even attempted to cross, who even attempted to seek safe haven in Southeros, were either killed by the shooting of the ABSS, drowned in the Rocky River, or were either so paralyzed from fear that they would not even attempt to.
Counsel, I have a question. Your submission regarding how Southeros also committed gender apartheid, are you alleging a factual error here, or what is that you're requesting us to do? Because we're here to review the pretrial chamber decision, which does not include any allegations or any evidence involving your submission, what you're arguing against. So what is an error that you're alleging here?
Your Honor, it is our position that we are simply establishing that the gender apartheid was committed by both Northeros and Southeros to further bolster our point that the women or the victims of Northeros could not escape because they were both subjugated by both Northeros and Southeros on both sides, Your Honor. With that, Your Honors, I will now proceed, Your Honors, to why the crime of gender apartheid does not just meet the subjective elements under Article 7(1)(k), in that it is of a similar nature and gravity to other listed crimes. However, it cannot be subsumed under any of those other listed crimes. Your Honors, you posed a question earlier about why it cannot be subsumed under apartheid, because apartheid immediately connotes a race element. However, Your Honors, we are not extending the definition of apartheid. What we are merely doing as the victims is that we are adopting this definition of apartheid in that the sense that it is an institutionalized and systematic regime of oppression and domination of one social group over another, and with the intent to maintain that regime, Your Honors. We do not see that the crime of gender apartheid is a new other inhumane act, is a crime of apartheid, but that it is an other inhumane act. Moreover, Your Honors, the fact that we are proving this under Article 7(1)(k), adopting that definition of apartheid, means that it is only the crime of apartheid that encompasses this kind of institutionalization of oppression. But moreover, Your Honors, you might ask, and the defense might pose to you, why we are not submitting this crime under the charge of persecution. However, Your Honors, we have the same argument and that same defense, that persecution simply cannot encompass the systematic oppression of the women of Northeros, because not only were discriminatory laws put in place, but there was an intent to ensure that the women of Northeros could not escape and would forever have to live within that cage of oppression, marginalization, disenfranchisement, and restriction. However, Your Honors, I'll now proceed to a part of my submissions in which the prosecution was lacking, in the sense that not only is the crime of gender apartheid considered an other inhumane act under Article 7(1)(k), but that Vrager aided and abetted this crime under Article 25(3)(c), because that is precisely why we are here, Your Honors, to prove Vrager's culpability in this crime of gender apartheid. Your Honors, the aiding and abetting is considered met when two elements are sufficient, which is when the actus reus was committed or the mens rea. In this case, Your Honors, Vrager's actus reus is clear. Blagojevich in paragraph 196 provides that the actus reus is satisfied when the individual had provided either practical assistance or even merely moral support. Your Honors, in this case, Vrager meets both. It is clear, Your Honors, that Vrager deployed the ABSS. He personally negotiated with Southeros to install this shoot-to-kill system along the border of the Rocky River. But we understand, Your Honors, that what is ultimately at contention here is Vrager's mens rea to aid and abet the crime of gender apartheid. Your Honors, as found in paragraphs 93 to 94 of Bemba, that the aider and abetter to satisfy this charge under Article 25(3)(c) must have had the intent to facilitate or advance the commission of this crime. Moreover, Your Honors, this is qualified by paragraph 1820 of Popovich, which provides that the aider and abetter need not share the same exact intent as the direct co-perpetrators. Instead, it is sufficient that the aider and abetter had known and had the intent that their provision of practical assistance or moral support would further and facilitate this crime. Your Honors, the facts are clear, that the Ballon regime had issued the 4 decrees in November 2021, which caused the mass exodus of women into Southeros. Vrager had contracted with Southeros in May 2022, and even before that, Your Honors, the United Nations Human Rights Council in the facts had already submitted a resolution in which 40 states voted against this gender apartheid in Northeros. Your Honors, there were sufficient public records available that Vrager must have had known of the situation that was ongoing in Northeros. However, he decided to contract with Salderos anyway, engaged in these negotiation plans to design a system that operated only within an environment in which only women had to flee. This clearly shows that Vrager had intended the ABSS to be deployed along the Rocky River to ensure that the women of Northeros could not escape, or at least would be so intimidated by fear that they would not even try to. Your Honors, the defense might try to argue that there was a fail-safe mechanism, or that Vrager had asked Northeros to post signs along the border. But Your Honors, it is our submission that this only shows his premeditation, his intent, his knowledge that the ABSS would be particularly used and deployed in such a manner that would kill them and entrap them within that cycle of oppression. Your Honors, moreover, the defense might try to argue that Salderos had lawful means to protect their borders. But Your Honors, this can never be an excuse, a justification for the ABSS to be deployed in such a manner that only killed women and ensured that they could not even turn back, because either they were killed by the ABSS itself, or they would be drowning in the Rocky River, or would not even attempt at their escape, Your Honors. With this, Your Honors, if there are no further questions, I will now proceed to my third prayer, that Vrager committed an offense against the administration of justice under Article 71C. Your Honors, we understand that the primary question that must be answered under this prayer is whether or not the publication of an unredacted HRI report already meets this threshold to commit an offense against the administration of justice. And it is our position that it does. Your Honors, this crime is met when the actus reus and mens rea concur. And in this case, Vrager had committed both, because the defense might have you believe that Vrager could not have published the unredacted HRI report because it was done through CyberLeaks. But Your Honors, as found in paragraph 17 of Appendix B, Vrager had full control of CyberLeaks. He authenticated these documents himself, and that nothing was published without his say-so. Your Honors, this shows that Vrager had received the unredacted HRI report, read it, understood that it contained the names and identifying information of the witnesses, and decided to publish it anyway. Your Honors, as can be gleaned from the facts, that the redacted HRI report was already publicly made available online. This redacted HRI report already contained information that was of a public interest, and there was no other need or reason for Vrager to publish the unredacted HRI report, which deliberately exposed the names of these witnesses to the rest of the world. The defense might have you believe, Your Honors, that he only did it in the interest of press freedom. But it is our position, Your Honors, that press freedom, journalism even, is bound by ethics. And journalists and every person in the world that may publish or that is engaged in this field, such as Vrager through CyberLeaks, understands that redacted names of confidential witnesses or people that may have been involved in OTP proceedings or cases must be kept secret. Their information and their safety must not be compromised. But this moves us, Your Honors, to why Vrager had the mens rea to obstruct the administration of justice. It is clear, Your Honors, that the witnesses that had given their testimonies to HRI were witnesses that had closely worked together with him. Your Honors, moreover, these witnesses had even shown his culpability in the crime of gender apartheid. And if these witnesses were to further proceed or to further cooperate with the ICC in proceedings that may implicate him even more, it would only ensure that Vrager is criminally liable for that crime of gender apartheid. It shows then that Vrager clearly had the intent. Yes, Your Honor.
Before you continue, you keep referring them as witnesses. And in the facts, it's understanding of the chamber that they were not interviewed by the prosecution. They haven't appeared before this chamber. So is it your submission they qualify as witnesses within the meaning of Article 71C?
Your Honor, it is our position that even if they were not interviewed personally by the OTP, that they are still considered witnesses. Particularly under paragraph 46 of Gesheru, even individuals who are considered potential witnesses may still be considered witnesses by the ICC because these individuals possess knowledge and information that may be useful in the ICC to further proceed with investigations, proceedings, cases or trials against accused individuals. With that, Your Honors, it is sufficient and it shows that the witnesses such as Morgul and Shrieker were considered witnesses by the ICC and that their disappearance then, or their inability to cooperate anymore through Vragar's publication of their names makes Vragar culpable. To conclude this third prayer, Your Honors, that Vragar did not have a duty or obligation or even a reason to publish this unredacted HI report, which contained no new information other than what was already publicly available online, other than the identifying information and names of these witnesses, which compromised their safety and further jeopardized ICC proceedings because now they can no longer be called on by the court to cooperate or corroborate even their testimonies before them. It also sends a chilling effect to other future witnesses because now it is evident that now their names or their identifying information is not safe and cannot be protected sufficiently. To conclude my submissions, Your Honors, that when we impose standards when the Rome Statute's clear text is sufficient, we erect barriers to justice when we do not need to. When laws oppress women, banishing them from workplaces, classrooms, and public life, gunning them down in fear in their escape, or terrorizing them into submission, and yet we fail to call this gender apartheid. We are declaring to the entire world that both society and the law does not have space for them. And when armed dealers profit from their oppression, and when witnesses had disappeared who were crucial to proving their plight and Vragar's involvement in this situation, we are etching into stone their impunity. Your Honors, the women of Northeros stand at the intersection of these injustices, and we would like to highlight to the court. Thank you and good day.
Thank you very much. I give now the floor to counsel for the defendant.
Mr. President, Judge Kim, Judge Mary-Lise, may it please the court. As earlier introduced, my name is Ms. Leah Yo, and I act for the defendant, Mr. Eric Vragar, before today's appeal. Your Honors, my client Eric Vragar is the CEO of Vragasoft Corporation. At the request of the Southerose government, his company entered into a $120 million border security project to help Southerose address concerns over undocumented migrants. The prosecution now seeks to criminalize his involvement in this project, alleging complicity in a neighboring state's purported crimes of gender apartheid. This is despite his lack of ties to the Northeros Bellerin regime. In this regard, we respectfully request this court to dismiss this appeal on 3 grounds. First, that this court lacks jurisdiction over Vragar, as he is not considered a Pentos national for the purposes of Article 12(2)b of the Rome Statute. Second, that the crime of gender apartheid is not recognized under Article 7(1)k, and in any event, that my client is not individually criminally responsible for the aiding and abetting of such a crime under Article 25(3)(c) of the Rome Statute. And lastly, that my client is not liable for committing an offence against this court's administration of justice under Article 71(c) of the Rome Statute, as the requisite material and mental elements have both not been satisfied. With this, I turn to my first submission on the issue of jurisdiction. It is our position that this court lacks jurisdiction over Vraga because he cannot be considered a Pentos national for the purposes of Article 12(2)(b) of the Rome Statute. Now we note that earlier my learned friend had stated that the term national under Article 12(2)(b) is clear on its face. However, we disagree, and this is why we must have recourse to rules of interpretation pursuant to the hierarchy of laws in Article 21(1) of the Rome Statute. And we note that Judge Mary-Lees had earlier queried the Prosecution Council on their reading of Article 36(7) of the Rome Statute and whether it can be read in context with Article 12(2)(b), to which the Prosecution Council argued that this is a provision dealing with a wholly separate matter, a matter relating to the selection of judges, and therefore it cannot be imported into Article 12(2)(b), a matter dealing with nationality jurisdiction. However, it bears noting that in the 1955 International Court of Justice case of Nottebohm, which Mr. President had raised some questions over, this was the exact same approach that was taken by the court at page 22. In coming up with the genuine connection test, the court made reference to concepts inherent in Article 3(2) of the ICJ statute, which is in pari materia to Article 36(7) of the Rome Statute in formulating the genuine connection test. This just goes to show that it is possible to read a provision relating to the nationality of judges in context with Article 12(2)(b) dealing with nationality jurisdiction. But going beyond reading within the Rome Statute, it bears noting that it is a rule of international law that the genuine connection test should be used for determinations of dual nationality. Now we note that my learned friends had argued that generally nationality is a matter which should lie in the domain reserve of every state. And we do agree, but it is precisely because if courts were to confine themselves to the view that nationality is exclusively within the domestic jurisdiction of the state, it would be necessary for them to find that they were confronted by two contradictory assertors made by two sovereign states, both of equal weight, which would oblige them to allow the contradiction to subsist and thus fail to resolve the conflict submitted to them. And this was the rationale that the court in Nottebohm at page 21 used when formulating the genuine connection test. Now we note that the Victims' Council had earlier raised the point that there has been no objection by the state of Davos, and they have in fact accepted that Vraga is a dual national of both Davos, a non-state party, and Pentos, a state party. However, it bears noting that at page 3 of the lower court's decision, at paragraph 8, Davos has already expressly objected to this court's jurisdiction by informing the registrar of the court that they would not pursue charges against my client nor cooperate with the ICC's proceedings because they were not a party to the Rome Statute. And therefore, this is an opportune time for the sufficient link test to be applied, such that Davos's conflicting claim and choice not to delegate jurisdiction to this court can be assessed against Pentos's decision to delegate jurisdiction to this court. And when we apply the sufficient link test, it is abundantly clear that my client only has sufficient links to the state of Pentos. To the state of Davos. He has only lived 7 months of his past 53 years of existence in the state of Pentos, but for the past 53 years of his life, he has been educated in Davos in a pledge of allegiance signed on for Davos military service, continues to pay millions of dollars to the Davos internal tax revenue. and therefore it is abundantly clear that he only has a sufficient link to Pentos, and therefore this court lacks jurisdiction. Your Honours, but this is not the only ground that this court should deny the confirmation of charges against my client. The prosecution has also brought a charge under Article 7.1k and Article 25.3c of the Rome Statute relating to my client's alleged aiding and abetting of the crime of gender apartheid under Article 25.3c of the Rome Statute. And as Vraga's defense,
Counsel, sorry.
Judge Marilis.
Just before you go on to your submissions on gender apartheid, I want to just go back to this question of jurisdiction. So if I understand your submissions correctly, you're saying that it's a matter for national authorities to determine the nationality of their individuals. Is that what you're submitting?
National authorities can decide the conferral and acquisition of nationality, but the case before the court today is on the recognition of my client's nationality.
Is it for this court to make a determination on essentially domestic authorities' law on how they confer nationality? Because ultimately speaking, all this court needs to be determined is whether the individual is a national of the state party, which by your submission, he is. So surely the exercise stops at that point, no?
The exercise does not stop at that point because while conferrals of nationality does indeed lie within every state's domestic purview, when it comes to the recognition of one's nationality in the international realm, that is something that this court should decide with reference to the sufficient link test. Now moving back to my submissions under issue 2, we, as Vraga's defense counsel, since we are most concerned with his individual criminal responsibility, we begin with our submissions under Article 25.3c. And on this, we note that Judge Kim had earlier queried the victim's counsel on their position that Southerose might have been liable in these purported crimes of gender apartheid. And there appears to be some confusion as to who we represent at this point. To be clear, we do not seek to speak on behalf of the Southerose state. We only are here to establish that my client did not possess the requisite purpose to facilitate the crime of gender apartheid. And the victim's case turns heavily on the fact that my client allegedly knew that the ABSS would lead to the deaths of thousands of civilians and that it was meant to prevent them from crossing into Northeros. And these are facts which are found at page 9 of the lower court's decision, paragraph 10. It further reads that Morgue stated that this was the whole point of the project. However, this piece of evidence that the victim's counsel relies on to prove my client's purpose does not actually help them as much as they state. This only goes to show that my client might have had knowledge of the unfortunate consequences of his action, but not that he had the requisite purpose to facilitate the gender apartheid. And we also raised issues with the quality of evidence at this stage of proceedings. We do acknowledge that pursuant to Article 61.5 of the Rome Statute, that my learned friends are allowed to rely on documentary evidence at this stage. However, as noted in the 2013 Bagbo pre-trial chamber decision at paragraph 31, a decision that we note that Mr. President was part of the quorum for, it was stated that notwithstanding the fact that the prosecution can rely on documentary evidence at this stage of proceedings, it does not then diminish the intrinsic shortcomings of hearsay evidence. But notwithstanding, we are willing to meet our learned friend's case at its highest and still state that he did not have the requisite purpose to facilitate gender apartheid. And indeed, we state that his actions were inconsistent with one who wanted to facilitate gender apartheid. When he was designing the ABSS system, first and foremost, it was a gender indiscriminate system. It shot at anyone who attempted to cross into Southerose. Second, he put in place warning signs to warn anyone that was attempting to cross that they might be shot. And third, he even included a fail-safe mechanism. But perhaps what would best assist this bench in understanding my client's mental state is to take a step back and look at why Southerose even had contracted with him in the first place. Sadaros was faced with an undocumented migrant crisis with 60,000 undocumented migrants within their shores. As a result, they were faced with an increase in crime rates, economic strain, and domestic turmoil as a result of the mass protests that erupted across the entire state of Northern in the spring and summer months of 2022, facts that can once more be found at paragraphs 7 and 8 of Appendix B. And this was when my client entered into the picture and attempted to help Sadaros address their concerns over undocumented migrants. At the end of the day, Your Honours, what we are saying is that a distinction must be drawn between preventing women from leaving the state of Northern and preventing people from reaching the state of Sadaros. The latter, which was what my client intended when he entered into the contract, and the former, an unfortunate byproduct of his actions. And there indeed exists some doubt as to whether the principal perpetrator's offence is even made out under Article 7.1k. And we note that Article 7.1k is a residual provision that allows for this court to expand the scope of crimes against humanity so long as it's not done uncritically. And this provision was included in the Rome Statute based on the fact that an exhaustive enumeration of crimes against humanity would not be possible for drafters when they were drafting the Rome Statute. And the prosecution and victim's case is that the crime of gender apartheid is similar to the crime of apartheid under Article 7.1j. However, as noted by Judge Mary Lees, there are some concerns about decoupling the method of oppression from the target group of race as confined by Article 7.2h of the Rome Statute. And indeed, we take the same position. The core of apartheid is twofold. The method of oppression cannot be divorced from the target group, and this is also evinced through a scanning of the travel preparatoires, whereby notwithstanding the long-standing history of condemnation towards the crime of apartheid, the inclusion of the crime of apartheid into the Rome Statute was considered a remarkable feat, given several Western states' reticence towards signing on to the Apartheid Convention, which is one of the key antecedents of the Rome Statute. And it was only because of a coalition of sub-Saharan African states with the unassailable oral authority of their own painful national experience that the crime of apartheid was recognized and enumerated under Article 7.1j. And when interpreting the crime of gender apartheid under Article 7.1k, this court must consider the signaling effect that it would have to these African states and instead choose to uphold the special evil and condemnation that apartheid has historically held. And with this, I turn to my last submission on the issue on the crime against this court's administration of justice. And it is our position that my client did not commit the offense because there's no proof that he had authorized the publication of the report, and second, that he did not intend to interfere with the attendance of witnesses at trial. On the point of authorization, my learned friends once more rely heavily on Shrika's statement found at page 10 of Appendix B at paragraph 17, that nothing is posted without his say-so. However, it bears noting that at the time that Shrika's statement was made, this was a whole month before the unredacted report was even posted onto CyberLeaks. Therefore, while it might evince some past conduct within the company of CyberLeaks, it does not then definitively prove that it was my client who was behind the posting and the authorization of the unredacted report. And now moving to the mental element of the crime, as noted in the 2016 Bamba Trial Chamber decision at paragraph 50, the accused person must both know that their actions would lead to the interference of witnesses and have acted with the purposeful will to interfere with the attendance of witnesses at trial. And the Prosecution and Victims Counsel is inviting this court to draw an inference that my client had the requisite intent based on the sole fact that he had disclosed the identities of witnesses. However, Your Honours, this is one inference out of a spectrum of several other inferences that this court could draw. The most altruistic being that, notwithstanding this report incriminating him against crimes against humanity, Braga was simply trying to further his company's mission of transparency. On the other end of the spectrum is the prosecution and victims case that my client attempted to interfere and scare the witnesses away from attending trial. But a middle ground is that simply because his name was already out in public through the redacted version of the HRI report, my client thought that it might be prudent for the court of public opinion to assess the weight of the evidence given by these confidential witnesses and therefore went ahead to post this unredacted report. And therefore, it is our position that my client did not have the requisite purpose to facilitate gender apartheid. And another point that the Victims' Counsel had raised is that we cannot hide behind this term of journalistic freedom in trying to justify my client's position. And indeed, we do note that there are tensions between the safeguarding of the integrity and efficacy of court proceedings with journalistic freedom. But this point has already been noted by the International Criminal Tribunal of Yugoslavia's 2007 Majetic case at paragraph 81, that indeed do exist limits to journalistic freedom, but these limits only exist insofar as there has been a court order in place or there have been witness protection measures in place, both of which are not found on the facts of our present case, and therefore it cannot be said that my client knew or intended to interfere with the attendance of witnesses at trial. Your Honours, for the past 19 minutes, I have shown why there is no basis to disturb the lower court's finding on all three issues. At the core of the prosecution's case, they attempt to attach liability to my client through his commercial proximity to alleged crimes, despite lack of evidence that he had any purposeful intent. The confirmation of charges proceedings serve two vital functions. One, to filter out cases which merit proceeding to trial, and second, to safeguard the rights of defense against wholly unfounded and wrongful charges. Where there are insubstantial grounds to believe that my client has acted in a manner that deserves prosecuting before this court, the latter function must prevail. And therefore, the defense respectfully requests this court to dismiss this appeal. Thank you, and may it please the court.
Thank you very much. Any questions by the bench? No? Then we have a round of rebuttals, and I understand that each party and participant has 10 minutes. And again, I give first the floor to the prosecution.
Mr. President, Your Honours, in my rebuttal I would have three main points to make. Firstly, concerning the liability of the defendant and the requirements of the purpose requirement under Article 25(3)(c concerning his mens rea. Secondly, concerning the case of evidence at hand and how allegedly one single piece of evidence would not suffice for the court to grant the confirmation of charges by virtue of Article 61(7) of the statute based on substantial grounds to believe. And thirdly, I would like to make some comments concerning the definition of nationality and how the court should deal with nationality as regards to an international institution. First of all, concerning the issue of liability and the defendant's purpose element, the prosecution would like to emphasize its agreement with the defense counsel that a purpose requirement under Article 25(3)(c establishes a higher mental threshold concerning the aiding and abetting of a crime. And the prosecution would also like to note that the legal representative of the victims has failed to show that Mr. Raga has this purpose requirement, although the legal representative stated a lot about the knowledge of the defendant, and the prosecution would ask how the legal representative would bring justice to the victims of gender apartheid in Northros if it fundamentally misunderstands the law of the statute and the purpose requirement under Article 25.3c. The purpose requirement under Article 25.3c stipulates that the accessory must have lent his or her assistance with the aim of facilitating the offense, as stated in paragraph 97 of the Bemba et alia judgment. And unlike the defense submission might suggest, the prosecution can infer the purpose of Mr. Raga without any doubt, as the court has also done in the past, for example, in the pre-trial chamber decision of Blé-Goudet in paragraph 170, where it inferred purpose from the participation in the inner circle of planning assisting acts, and also in the engagement in preparatory activities, as well as the anticipation of the use of violence. And what we note is that, as shown by Appendix B 8 and 10 of Appendix B, that Raga led the negotiations with Sadros and the development of ABSS itself, and was thus aware of ABSS intended forms of employment to entrap women and kill those fleeing. It was called the whole point of the project, as written in Appendix B10, that ABSS will fulfill this purpose of killing thousands of civilians, and that it would make it impossible for the women of Northros to escape the discriminatory policies of the Belen regime. So in this light, this shows that Mr. Raga indeed fulfilled the purpose element under Article 25.3c, even though it is an elevated mens rea requirement. Your Honours, proceeding to the next issue, if there are no further questions, the defendant stated that there would only be one single piece of evidence and that it would be insufficient for the pre-trial chamber to confirm charges based on that. Now, concerning Article 61.7, the substantial grounds to believe threshold, there need to be concrete and tangible grounds that underpin these specific allegations. In this light, we should note that concerning one single piece of evidence, it was noted in paragraph 76 of the Intaganda trial judgment, Your Honor, concerning the higher threshold of beyond reasonable doubt, that the court assessed that a single piece of evidence was sufficient to prove a fact beyond reasonable doubt, which is also supported by Rule 63.4 of the Rules of Procedure and Evidence, whereafter no requirement of corroboration shall be imposed legally. And we note that the Human Rights International report, while submitted to the Office of the Prosecutor as one piece of evidence per se, it consists of three individual pieces of evidence, namely the summary witness statements of Morgan and Shrika as direct evidence, and also the human rights investigation based on public records and governmental records. And also the qualitative assessment of the witness statements per se are to be seen of high probative value, as Ms. Morgan, for example, is the Deputy General Counsel of Ragasov Corp, as shown by Appendix B8, wherefore she holds detailed insider information providing trustworthy information on the contract with Sadros and Raga's involvement specifically therein. And Ms. Shrika, as Raga's assistant executive aide, as shown by Appendix B16, was familiar with Raga and his activities and thus provided trustworthy and truthful information on cyber leaks and also his conduct concerning Ragasoft Corp. This shows that Morgul's and Shrika's statements are already reliable. And concerning the human rights investigation, the Human Rights International investigation of the public records and the governmental records, they are to be deemed, by virtue of paragraph 30 of the Katanga and Ngujulu motions decision, presumptuously reliable when they provide information on their sources and methodology. And also, as applied in Bemba and in the Katanga and Ngujulu charges, the court has relied on NGO reports as evidence numerous times. And as shown in paragraph 4 of the case, Human Rights International is an internationally recognized NGO known for its meticulous fact-finding process, balanced and objective documentation, and the reliability of its reporting, providing information on its methodology and sources. And
sorry, I'm going to just interrupt you very quickly. How do you, because considering that we only have one report here and no witness statements, how do you propose that this court upholds the accused rights under Article 67(1)(e), to examine or have examined witnesses against him or her, considering that there are no witnesses in this case?
Your Honor, we note the right of the defendant under Article 67. However, we also note that, as the defense counsel correctly stated, that the prosecution may rely on summary and documentary evidence on this stage of the proceedings by virtue of Article 61.5 of the statute. And I would once again like to elaborate back on Rule 63.4 of the Rules of Procedure and Evidence, wherefore no legal requirement of corroboration shall be imposed. And in this light, as established of the qualitative assessment of the witness statements of Morgan and Shrika due to their high positions in Ragasoft Corp and concerning CyberLeaks, we believe that these witness statements and the Human Rights International investigation is sufficient for the substantial grounds to believe threshold under Article 61.7 of the statute.
But their evidence cannot be tested at all because they're not here. So how do you propose that the accused's right to, as you say, to examine the witnesses are upheld? The witnesses are not here.
Your Honor, in this light we note, as we are in the pre-trial chamber stage, there is no legal obligation for the court or for the defendant to pursue cross-examination of witnesses in this court, which would be a righteously right of the defendant in the trial chamber phase. And therefore we are relying on the documentary evidence pursued by Human Rights International, and especially concerning the fact that 2 witnesses have already been obstructed with under Article 71C, allegedly by the defendant, and therefore the prosecution is extra cautious concerning this particular issue.
But what happens when we get to the trial phase? Let's say if this case is confirmed, we're at trial, there are no witnesses, there's only one report. That is substantial evidence to meet the beyond reasonable doubt standard in your submission?
Your Honor, we note that if we would confirm the charges in the pre-trial chamber phase, there would still be 120 employees of Ragasoft Corp and also 60,000 of refugees in the refugee camps at Norderos, and also those who lost their relatives in the crossing of the Rocky River border and who maybe got killed by the ABSS system. So we know there is a broad pool of evidence that the prosecution would like to pursue witnesses from in order to cross-examine them later in the trial stage proceedings. Your Honor, briefly concerning the last issue, the prosecution would like to clarify that we note that nationality per se is not defined in the statute, and also the defense counsel did not accurately provide a definition of nationality per se. And as there is no, we should refer back to the Permanent Court of International Justice's Tunis and Morocco nationality decrees back in 1923, where it stated it is in principle within the state's domain, and it shall be recognized on the international plane if there are no prohibitive rules of international custom that would prohibit such nationality being recognized, for example, by international instances. And by virtue of the North Sea Continental Shelf case before the International Court of Justice that stipulates that customary international law is established by state practice and a sense of legal obligation or opinio juris, we state that no such principle that fulfills these requirements have been proven by the defense counsel, as such a genuine link principle is not a recognized principle of individual criminal responsibility, and even discussed in the realm of diplomatic protection. Your Honors, in this light, the prosecution would once again ask the chamber to grant the appeal as the pre-trial chamber committed errors of law under the statute.
Thank you very much. I give now the floor to the common legal representative of the victims.
Mr. President, Your Honors, once again, good day. Today, I have 5 points of rebuttal for the prosecution and for the defense. For my first point of rebuttal, Your Honors, is on the sufficient or genuine link principle. Your Honors, allow me to clarify that the sufficient and genuine link principle are not one and the same thing. In fact, the sufficient link principle is actually a principle that was used by the ICC itself in the cases of Mbarushimana and Bagbo, which only use it to confer or to determine subject matter jurisdiction. Moreover, Your Honors, contrary to that is the genuine link principle, which I think both teams have failed to recognize as a distinct principle. The genuine link principle that is enshrined in Nottebohm is the principle that refers to the genuine and social fact of attachment of an individual to a state party. However, even adopting this definition by the prosecution and the defense, that it is the genuine link principle that is in contention here, that is still not applicable in this case. Because as can be found in Nottebohm, that the genuine link principle was only applied in a very strict manner, in the sense that it was only used to determine the diplomatic protection rights of a state to claim over Nottebohm, and that it only was applied to determine because there was an alleged arbitrary grant of nationality to evade the court's jurisdiction. But even assuming, Your Honors, that the genuine link principle may be applicable in this case, we submit that Vreegaard still has a sufficient and genuine connection with Pentos. This is because Vreegaard did not get or have his Pentos nationality through any arbitrary grants. Instead, he only earned or he had gotten his Pentos nationality through the principle of jus soli. Your Honors, jus soli is a customary international law principle which recognizes that individuals are bona fide, legal, and formally recognized nationals as soon as they were born in the country that recognizes jus soli as a bona fide link to that state party, to that state. But second, moreover, Your Honors, the defense tried to posit that dual nationals should be treated in light of Article 36(7) of the Rome Statute. However, this is a premise we reject, and instead, this actually bolsters our point, Your Honors, because, as can be gleaned, Your Honors, that the drafters of the Rome Statute already knew of the existence of dual nationals because they codified the qualification of dual nationals of judges under Article 36(7). However, as can be gleaned from the facts, there is no similar test to assess the strengths or genuineness of one's connection to a state party under Article 12(2)b. This shows that the drafters intended that for Article 12(2)b to encompass nationals, dual nationals, as long as they are formally and legally recognized by that state to be a dual national. However, Your Honors, the defense was misappreciated in their contention that Davos had not cooperated with the ICC, and thus Vreegaard cannot be brought to the ICC's jurisdiction. However, they have mistaken this appreciation of the facts, Your Honors, because Davos only said that they would not cooperate with the ICC's proceedings, and not that Vreegaard was not a national of Pentos. But moving on, Your Honors, to my second point of rebuttal, that the defense tried to contest the probative value of the HI report. However, as can be found in the cases of Almadi or Bemba, that even a single report that was posited by a creditable or even legitimate non-governmental organization such as Amnesty International already suffices and can already be sufficient grounds for the ICC to take that into consideration. There's no need for any witnesses or any additional documents if it is not available. But moreover, Your Honors, that then begs the question that the reason of why the witnesses cannot be called on to corroborate their statements before the court. Your Honors, whose fault is that? Your Honors, as found in paragraph 2 of Appendix B, the witnesses had given their testimonies on the condition of anonymity. This shows, Your Honors, that they knew that if their names were publicized to the entire world, that their safety would be jeopardized and compromised. And because Vreegaard has done exactly that, the witnesses have now disappeared and are no longer able to corroborate their statements before the court or can be called on to testify anymore on Vreegaard's involvement. But moreover, Your Honors, that the defense tried to posit that the ABSS was merely a deterrent machine to ensure that Southros had secured their borders. But it is our submission that this is incredibly inhumane. Your Honors, there was no reason for Southros to deploy the ABSS, a shoot-to-kill system of autonomous weapons, Your Honors, that shot refugees, women, as soon as they crossed the border. Your Honors, Southros had $120 million US, and instead of using this to reinforce their police force, Your Honors, or to employ non-lethal means, they instead deployed a weapon that ensured that the women of Northeros who only had a minimal chance of survival, that survival became zero. But on to my fourth point, Your Honors, the defense tried to posit and gave you a historical lesson of apartheid. But Your Honors, While we can see that apartheid refers to race, we are not submitting that gender apartheid qualifies under apartheid, but merely we are adopting this definition because we recognize that the oppression that the women of North Rose are facing right now is comparable to that nature and gravity that the South Africans had experienced back in the day. But even then, Your Honors, even if we can see this definition of apartheid for it to be apartheid, Your Honors, that Katanga says that there is no need for a crime to be of customary international law for it to be considered an other inhumane act, as long as it meets all the material elements such as contextual, subjective, and objective. Moreover, Your Honors, in the cases of Ongwen, in the cases of Katanga, forced marriages and destruction of cultural sites were not considered customs in international law, and yet they were still considered as other inhumane acts under Article 7.1k. And for our last point of rebuttal, Your Honors, that the defense tried to highlight or tried to pose to the court that the mission of Rhaegar was ultimately to increase transparency because the unredacted HRI report was made public and so that the public could assess the weight of evidence with regard to the unredacted HRI report. However, this is extremely unreasonable, Your Honors, because as soon as this unredacted HRI report was found on Rhaegar's desk for him to authenticate, it contained the OTP login markings. This shows, Your Honors, that Rhaegar had known that this confidential report had come from the OTP systems, known that the redacted report was already publicly made available online, saw that the names of the witnesses were unredacted through this report, and decided to publish it anyway. We would like to highlight to the court that the society does not assess the strengths or weights or even credibility of a report when it comes to the court's proceedings. Instead, that should have been left to the OTP to assess the credibility or strength of that report and their testimonies. And looking at the facts, Your Honors, that it has been over a year, Your Honors, since the witnesses had disappeared, because they disappeared as soon as the report was published in April 5 of 2024. Your Honors, the court has now been unable to proceed with these charges against Rhaegar today. To conclude my submissions, Your Honors, that the failure to recognize this crime of gender apartheid, the systemic erasure of an entire women population's humanity, is not merely to tolerate impunity. It is to force victims to wage their fight in the dark, armed with nothing more than laws that are too afraid to speak the truth of their suffering. To deny them that dignity of recognition is to perpetuate their torment under a shadow the world ignores. Just as we once did with the Bosnian camps, the Yazidi women who were enslaved and sold in public markets, and the Rohingyans who fled burning villages. Your Honors, this court cannot condemn the architects of atrocity while excusing those who armed them. The law did not exonerate the Nazi bankers who funded the wars, Your Honors, nor the engineers who built the Auschwitz crematoria. We must not shrink from doing the same now, simply because the victims are the women of Northeros. Mr. President, Your Honors, Rhaegar did not merely profit from this crime, but he built the cage that made it inescapable. We want to highlight that there is no neutral commerce in oppression, because profit cannot absolve complicity when price is paid in human lives. Your Honors, the women of Northeros deserve more than our pity. They deserve to see the light of justice, and for the whole world to finally bear witness to the fact that they are not the exception, but instead only the latest in an ancient line of women whose hopes, dreams, and lives have been crushed under the boot of sanctioned oppression. Thank you, and good day.
Thank you very much. I give now the floor to the defendant or the counsel for the defendant.
Mr. President, Judge Kim, Judge Mary-Lise, 5 points in sur-rebuttal. My first point in sur-rebuttal is a more general one, cutting across all 3 issues pertaining to the matter of evidence. And earlier, the prosecution had argued that the singular HRI report is sufficient at the confirmation of charges proceedings, to which Judge Mary-Lee raised some concerns about the rights of the defense under Article 67(1)(e). And further, the prosecution then went on to argue that they might be able to proffer more evidence at trial, collecting them from the Northeros women or the 120 other Vragasoft employees. However, as noted by the 2013 Bagbo pretrial chamber decision, the prosecution is meant to present their strongest possible case based on a largely investigated case at the confirmation of charges proceedings, and bearing note that these proceedings have begun more than a year ago, this is merely the prosecution's last-ditch attempt to bring this case further to trial when it should be stopped at the confirmation of charges proceedings. My second point in rebuttal goes towards the issue of nationality jurisdiction, and the Victims' Counsel in their rebuttals had conceded that at some points the sufficient link test might apply. However, they stated that given that the jus soli can constitute a sufficient link to the state of Pentos, since there was no arbitrariness when the conferral of nationality was done, therefore, Vraga would still have a sufficient link to the state of Pentos. However, it bears noting that in the ICJ 1955 Nottebohm case, at page 25, the sufficient link test was always meant to be a relative assessment. Therefore, when we are comparing Vraga's links to the state of Pentos, where he was only there for 7 months out of his 53 years, with the fact that he has for the past 53 years of his life made Davos the very center of his life, it is abundantly clear that my client should only be considered to have a sufficient link to the state of Davos. And going further, given that there is no renouncement mechanism in Pentos law, his maintenance of Pentos nationality is at best involuntary. I turn then to my third point in sur-rebuttal, where the prosecution earlier argued that knowledge can lead to an inference of purpose. And we do agree, knowledge and circumstantial evidence is how this court usually establishes purpose, but it cannot be done on the facts of our case. And the prosecution relies heavily on my client's knowledge of the lethality of the ABSS to impute purpose onto my client. But my client never intended for the ABSS to be so lethal, and that was why he put in place this 30 seconds fail-safe mechanism. And what it means is that each and every time the ABSS fired a shot, it was because the Southerose border security personnel, who was meant to always be manning the ABSS, thought it prudent not to deactivate the system. And therefore, the lethality of the ABSS and the Southerose border security personnel's lack of utilization of it cannot be then used to impute purpose onto my client. Now, my fourth point in sur-rebuttal goes towards the Victims' Counsel's narrative or what it could have been like when the unredacted HRI report was placed onto my client's table and that he had allegedly seen the confidential nature of the document. But these are all mere assertions. If we look closely at what the HRI report says at page 10 of Appendix B at paragraph 17, all they have to rely on is Shrika's statement that nothing is posted without his say-so. This does not evince the degree that my client had seen the report, nor whether he actually had sight of the report, and therefore the Victims' Counsel is merely asking this court to draw a far-fetched inference. And my last point in sur-rebuttal goes towards the assertion that it is the Victims' Counsel stated that it is unreasonable for the defense counsel to say that my client had no such intention to interfere with the attendance of witnesses at trial because we were trying to further our client's company's mission of transparency. And indeed, we do not wish to speculate what my client's true intent was. But the point that we are trying to drive through is the very fact that there are so many other inferences that this court could possibly draw as to my client's intent. It then only goes to show that my learned friends have not shown a clear line of reasoning underpinning their allegations, which is needed at the confirmation of charges proceedings as noted in the 2011 Barushimana pretrial chamber decision at paragraph 40. And unless this court has any further queries,
I don't think so.
this concludes my sur-rebuttals. Thank you, and may it please the court.
Yeah, thank you very much. We will leave now the courtroom to retire to the deliberation room for a little bit more than 30 minutes. You are, of course, allowed to leave the courtroom, also the public gallery, but please be back at 11:45, I think. Yeah.
All rise.